Hi, I'm Darcel Lobo. I own Dow Law Firm, and today we're going to answer the question of, can you buy a home in the name of your revocable living trust? So let's say you have a revocable living trust, you're thinking of forming one, and you're thinking about the future as you acquire real estate in the future. And maybe you've heard that you want to make sure that you get any real estate that you purchase into the name of your revocable living trust. So when I'm talking to clients about trust and about funding them and about any future real estate they may buy, one of the things that I tell them is that, as far as the long term with your trust, we have to make sure that the trust, and I'm going to just call it a trust for ease of the video today, but I'm talking about a revocable living trust, but I'm just going to say trust. So as you acquire future real estate, after we've formed the trust, you've signed it, we've done everything that we need to do for your trust, but as you continue on in the future, if you buy additional real estate, you have to make sure that we get it into your trust. So I tell most of my clients is just give me a call, let me know if you buy future real estate, and we'll make sure we get it into your trust. And so one of the questions can be, well, when I buy that future real estate, can I just buy it in the name of the trust, or do I have to wait until after I bought it and then transfer it later? And that's gonna depend. And I think you're gonna find that most lawyers' answers on any question are gonna be it depends, but I'm gonna tell you why it depends. Because the answer could be yes and the answer could be no. If you are paying cash for the property that you're buying, then yes, you can just buy it in the name of the revocable living trust. And in doing so, you won't need a deed later after closing to be able to transfer it over. So if you're paying cash, great. If you are getting a traditional, conventional loan, if you're getting a mortgage on the property, that mortgage lender is most likely going to require that you purchase the property in your personal name, because the loan, the mortgage that's going to be attached to that property will also be in your personal name, and those two things need to match when you are buying the property. So if you are financing that purchase through a mortgage lender, they're probably going to tell you that you need to buy it in your personal name. Then comes the question of, well, after I've bought it, is it okay that I transfer the home out of my personal name into the name of my trust? And so in my experience, I've been doing this for 16 years, real estate planning, things like that, is that yes, that's fine, because the person that owns the property, you are the same owner as the trust, right? It's one of the same. And so you're not actually selling the home to someone else. You're not adding someone else onto title, because you still have full and complete control over the trust and over the assets of the trust, including the real estate. And the mortgage that you have on that property is attached to that property. The lien is going to follow. If you want to be sure of this, you certainly can just talk to your lender and ask them, hey, is it okay if I transfer this over to my trust? And you can let them know kind of what's going on with your estate plan and get their sign off or buy off on it. Some lenders, you may have a hard time just getting a definitive answer out of them, but I have never seen or experienced a client who's had a lender come back and say, no, we don't like that you did that, you can't do that. If that did happen to you, in a worst case scenario, you can just transfer the home out of your trust back into your personal name. But again, I've never seen that happen. So not to say that it couldn't happen, and there might not be a mortgage lender who does have an issue with it and wouldn't let you do it. I just haven't seen it. I haven't seen that be a problem. And as long as the homeowner continued to make the mortgage payments on time on that property, I haven't seen a mortgage company raise it as an issue. Again, not to say that it doesn't happen, but I just haven't seen it. I haven't had clients contact me that's been their experience, that they've had an issue with the mortgage lender. And I think if the mortgage lender had a question about, like, what exactly are you doing, you can always give them a copy of your certification of trust, which is like a short summary of your trust and verifies the name of the trust, who's authorized, the date of it, things like that, that will show the mortgage company, like, yes, this is your trust, this is your estate plan, and we're just doing this for estate planning purposes. So again, if you have a trust and you have real estate that has not been transferred into that trust, you need to make sure that you do so. Because in order for your revocable living trust to work, it has to own the asset. If the asset is not in the trust or doesn't have a beneficiary named, then it's going to go through probate to get into your trust if you have a pour over will. If you don't have a trust yet and you're thinking about getting one, you're not sure if it's right for you, feel free to reach out. We're happy to have a consultation to see if it's right for you and help you assess that. I am only licensed in Washington State. So if you are located outside of Washington State, I would not be able to assist you, unfortunately. I would recommend you contact your state bar association to see if they can get you a referral to an attorney in your state. But if you're in Washington, I'd be happy to have a consult with you and discuss your estate planning needs, if a trust is right for you, and help you answer those questions. Our number at the office is 206-408-8158. Thank you and have a great day.